program. So to introduce our panel and to get us all started, Justice Sabrina McKenna.
Aloha. Aloha. Everyone can hear me well? Wonderful. Thank you. It's truly an honor to be able to moderate this first panel of the annual Civil Justice Update. And as Donald has mentioned, I'm not going to get into the details of our illustrious panelists here today. Please check it out, but just a brief introduction. We have, to my immediate right, Robert S. Peck, who is the founder and the president of the Center for Constitutional Litigation. He's a regular in the United States Supreme Court. He is considered to be one of the most sought after appellate litigators within the plaintiff's bar. So he'll be presenting more from that perspective. And please read his bio in detail. And to his right is Jeffrey Wyatt, partner of the Mass Torts Insurance and Consumer Litigation Unit of the Skadden Arps law firm. And he is also a regular litigator before appellate courts, state and federal system, as well as the United States Supreme Court. So we have two great panelists to speak to us today. They're going to be speaking for about 20 minutes each first, and then they'll be exchanging ideas. Then we do plan to reserve about 15 minutes for Q&A, and the way Q&A works is that we ask that people with questions go up to the microphones on each side to ask your questions of the panelists. So without further ado, I believe we have various topics we'll be talking about, but I'll allow them to go ahead and discuss them. So Bob, would you like to start? Or is it Jeff? Jeff's going to go. All right, thank you.
I'll kick us off. Thanks,
all right, thank you.
Thanks, Justice McKenna, for that introduction. Thanks to the Law and Economics Center for hosting this and having us here to speak with you, and thank you all for being here. As Justice McKenna introduced, work in the Mass Torts Insurance and Consumer Litigation Group at Skadden. Can you hear me? Is this coming on? Okay, it's coming in now. Okay. And so I represent defendants in product liability litigation and class actions mostly, and so I say that at the beginning because these comments will come from that perspective. I'm sure Bob will balance this out. Today I want to talk about two things that I think are relevant and topics of the moment for both state and federal courts, which is Rule 702 and personal jurisdiction. And so I'll start with Rule 702, which of course is the rule for the admissibility of expert evidence in federal court as well as in many corresponding state courts, or if the number's different, the rule may be the same. There is the whole Daubert-Frye distinction in state courts, but there's a lot of state jurisdictions that follow the federal Daubert and Rule 702 rules as well. So in federal practice, on December 1st of 2023, amendments to Rule 702 went into effect to make substantive changes to the rules. Maybe I think they were mainly intended as clarifying amendments, but on two important topics, or on three important topics. Number one is that the amendment made clear that the proponents of expert testimony have the burden of proving the admissibility of the expert's opinions by a preponderance of the evidence. Number two is that the expert's opinions have to stay within the bounds of what can be concluded from a reliable application of the expert's methodology. And number three was that the challenges to reliability of those opinions are matters for courts as gatekeepers of expert evidence to decide in the first instance, and not to just punt off to lay jurors. So with respect to that first issue about the burden of proof, the committee's intent was really to underscore a burden that it thought had been there from the beginning, which is that it is a burden that the proponent of the evidence bears to prove admissibility by a preponderance of the evidence. The committee was taking aim at a number of prior decisions that had said things to the effect that there was perhaps a presumption of admissibility when it comes to expert evidence, or that the law favors the admissibility of evidence, or that 702 is a low hurdle to admissibility. And the committee squarely took aim at those suggestions as potentially misleading or incorrect. With respect to that last issue about courts serving a gatekeeper role and not just delegating or deferring to the jury when it comes to expert evidence, these amendments, again, were introduced in part due to concerns that courts had previously gotten this question wrong, and it too often determined that issues that challenges raised to the admissibility of expert evidence went to the weight of the evidence as opposed to the admissibility of the evidence. And so just to take one example, there was a case that one of the authors of the amendment specifically flagged coming out of the U.S. Court of Appeals for the First Circuit called Millward versus Acuity Specialty Products Group. This is a case in which the plaintiff's theory was that benzene exposure could cause a certain kind of leukemia, and the district court had excluded the evidence on the ground, among other things, that the evidence was essentially fairly weak. There was no statistically significant evidence supporting the causal theory that the plaintiff's expert had proposed. But the First Circuit had reversed this, holding that the district court had focused too heavily on the lack of statistically significant epidemiological studies and had gone too far in evaluating the weight of the evidence. And so this is sort of an example of what the committee was trying to point out as an instance where the court was not performing the gatekeeping function that was intended by Rule 702. So we're just about a year in since these amendments have, since this amendment took place. And as we'll talk about in a minute, there have been similar amendments made in some state jurisdictions, and there's also a question of whether the amendments actually intended a substantive change or only to clarify what the rule should have meant all along, and thus whether an amendment is even necessary. But just to go through a few examples of how this has played out. In federal court, there's multi-district litigation pending concerning acetaminophen, the generic name for Tylenol, and whether acetaminophen exposure in utero can cause autism spectrum disorder or attention deficit hyperactivity disorder. And full disclosure, I'm involved in this case, so I may have a particular viewpoint on how it should have played out. But the way it did play out is the court entertained a Daubert challenge to the plaintiff's 5 experts on this topic, and it did conclude that those opinions were not admissible. And so just to give my perspective on the state of the scientific evidence, there's not a lot of strong evidence, a lot of evidence showing a strong association between the exposure and the conditions at issue. And to sort of try to cover this gap or to make the evidence stronger, the plaintiff's experts had kind of combined these two conditions, ASD and ADHD, and used the evidence from both of those categories to try to strengthen the overall picture of causation for the plaintiffs. And the district court dug into this, took a very close look at the science, took a very close look at the experts' methodologies, and concluded that there was not a reliable basis for combining these two different conditions to support their conclusions. In a similar matter, in the Onglyza litigation, which concerns whether certain diabetes drugs are capable of causing heart failure, not involved in this litigation, so more of an outsider perspective. In this case, the Sixth Circuit Court of Appeals affirmed a similar district court ruling. So district court looks at the evidence, determines that the scientific literature is not strong enough to support the causal conclusion that the plaintiff's experts are reaching. And an interesting point in this case is this decision was decided under the sort of pre-amendment Rule 702 or the old Rule 702. But the Sixth Circuit makes clear in a footnote that the reasoning of the lower court aligned with the updated Rule 702 since it properly placed the burden of showing that the expert was admissible on plaintiffs. And so it said that its reasoning would apply whether you apply the old rule or the new rule, suggesting that perhaps there's not really a difference between the two, but rather that the amended rule clarifies the old rule. One more case as an example, in Hill versus Medical Device Business Services in the Middle District of Tennessee, decided in August of this year. This was a case about a hip implant. And there were issues with the hip implant, unsurprisingly. That's why there's a lawsuit. And the plaintiff's expert was a metallurgy expert, and she opined that the cause of the injury was a metallurgical failure with the device as a result of a manufacturing defect. And this opinion also was found to be unreliable and inadmissible. Again, an example of the court sort of digging in and looking at the logic behind the expert's analysis. The expert's opinion was a sort of a differential diagnosis or a rule-in, rule-out opinion. So the expert had ruled in the possibility of metallurgical failure, which was within her scope of expertise. But she had not reliably ruled out other possible causes, such as angle of implantation, forces within the body and forces during surgery, because these were biomechanical issues that were outside of her expertise. And so the court determined she didn't have the expertise to do the rule out part of her methodology, so the methodology as a whole was unreliable. So these are kind of examples of cases, in recent cases, and all of these cases cite in varying degrees to the amendments of the rule, calling out that the courts have been directed to make sure that the proponents are bearing their burdens of proving that the evidence is admissible, but also that the court is acting as a gatekeeper and really digging into the facts and looking at the science that's supported that's cited in support of these opinions before making that determination whether it's reliable or not, and then deciding, okay, everything else is for the jury to sort out. A couple things to sort of think about going forward. So number one is I see these changes as good from a defense perspective, because these causation questions come up a lot in my practice, and often in cases, in my opinion, where the litigation is getting out in front of the science. But it is a two-way amendment. The proponent of the evidence, not just the plaintiffs, have to prove the admissibility of expert testimony, and that has already been applied as to defendants. So there's one example of this, the State Auto Mutual Insurance versus Freehold Management case from the Northern District of Texas. This is a case where an insurance company sought a declaratory judgment with respect to its coverage obligations after a storm in Texas damaged the roof of one of its insureds. And the defendant was the one whose expert was excluded in this case on the ground that, in essence, the meteorological opinion he offered was too subjective. But another example of a court really digging in, this is a decision that, if you're interested in it, really kind of parses the amendment and how it is correcting decisions that courts have made in the past. It looks specifically at Fifth Circuit precedent and how some of the statements of the Fifth Circuit in prior cases don't align with what the committee has now clarified Rule 702 is supposed to do. So again, while I see this as generally a course correction that will be favorable to defendants in product liability litigation, I think it is something that we will see action on both sides of the V in future cases. Now, one thing that this highlights, as I started out, Rule 702, obviously I'm talking about the federal rule, but there are many state rules that are modeled after the federal Rule 702, so it raises a question of, will the same standard apply in state courts, especially in state courts that follow 702 and Daubert but have not yet amended their rules? And there's actually one interesting example of this in the Zantac or ranitidine litigation in federal court earlier this year, maybe it was late last year. There was a lengthy Daubert ruling excluding general causation opinions that had posited that Zantac or ranitidine generically caused a certain set of cancers because it contained or it produced a known carcinogen, NDMA, when it was ingested. And very long opinion, goes through all of the epidemiology and the opinions of the experts and the literature underlying them, 300 pages long. And the litigation, that was essentially a end of case type Daubert ruling, because all of the cases pending in the multi-district litigation depended on this general causation theory. However, the litigation does live on in the sense that it's now on appeal in the U.S. Court of Appeals for the 11th Circuit, but it also lives on in state court. So as is often the case in mass torts, where a multi-district litigation is established and comes to house hundreds or thousands of cases, in federal court there's also parallel state court proceedings. And in this particular litigation, the same Daubert question was raised in Delaware State Court, and the Delaware State Court decided not to follow the federal ruling, and in doing so, it noted that Delaware has its own rules, it has its own precedents, even though it's a Daubert state. And there was no discussion of the amendment in this opinion, but it does sort of highlight that while there is some alignment between the way federal and state courts, in some cases anyway, follow Rule 702, they may diverge in their application, especially where there may not be the same amendments at the state level as there have been at the federal level. That being said, there are a number of states that have already adopted the same amendments that the federal rule has had made to it. So at least in Arizona, Kentucky, Louisiana, Michigan, and Ohio, those amendments have already been made and taken effect. They, I believe, have been proposed in some other jurisdictions as well, and I think over the next few years, we'll probably see a greater alignment between states that have followed Daubert fairly closely and the federal practice as well. There hasn't been a ton of activity yet in state appellate courts explaining the impact or significance of these amendments, whether at the state level or at the federal level, but there's been one Colorado Court of Appeals case that did point out that the rule had been amended at the federal level, but not at the state level. But then it went on to say that it would have resolved the case the same way regardless, because the same principles would have applied. So again, another decision out there sort of raising the question, if it's really just a clarifying amendment, do we even need an amendment at the state level to sort of understand that this is what Rule 702 means and how it should be applied? Why don't I stop there on 702? I want to talk about personal jurisdiction also, but maybe, Bob, you want to either address that or raise another issue.
I'd be happy to address it. Is this on? So first, let me start by thanking the Law and Economics Center for inviting me again to join you for this session. I've been doing it for a long time, and not quite the full 50 years that the Law and Economics Center has existed, but it sometimes seems as though. And I can't resist also giving a little plug for a book of mine that is being published next week. It's a book of Supreme Court justice anecdotes about everyone who's ever served on the U.S. Supreme Court. It's called Supreme Anecdotes, Tales from the Supreme Court, and it's gotten some nice early praise from as diverse a group of people as Erwin Chemerinsky, the dean at Berkeley Law, as well as a former Chief Justice of Texas, Wallace Jefferson. Let me start with first principles. I think it's always easiest to start with that when you talk about expert evidence. Daubert was an interpretation of the 702 as it existed at that time. And what it did was actually liberalize the admission of expert evidence. Previously, the Frye Rule had been applied in federal court and in most states. It was a general acceptance rule, meaning basically that you had to have established scientific evidence behind your expert opinion and presentation. What Daubert did was allow novel evidence in as long as it met certain reliability standards. And it also did have, as does all the other parts of the rules of evidence, a requirement that it be proven by a preponderance of evidence. The proponent of the expert evidence was supposed to justify it. And so none of that really changed. And so when the new 702 became the rule of court last year, what the advisory committee that helped draft it said is that we really weren't changing anything. We're emphasizing some things that we think courts were making mistakes about. And that was primarily the preponderance of evidence rule. So what we have is, again, still a reliability rule that talks about the reliability of the methodology the expert used, as well as the reliability of its application to that set of facts. That preponderance of evidence rule doesn't require you to say that this is better than anything, but that the reliability is met by that preponderance. When Jeff mentioned the Federal Court of Appeals that said scientific literature was not enough to support it, it struck me, without knowing anything about that decision, that that sounded an awful lot like the old Frye Rule, the rule that basically said it had to have general acceptance in the scientific literature. That's not what has to happen. And what courts did, which was part of the inspiration for the new 702, was that they often confused reliability with the weight of the evidence. And so therefore they said that goes to the weight of the evidence, so I'm not really looking at it. They did have to focus on reliability. They had to be convinced that this was a reliable, valid way of looking at this issue. And of course, Daubert and its progeny means it applies to all expert evidence, not just scientific evidence. And by that, it needs to make sure that we're not presenting essentially junk science to the jury. Having said that, the weight and credibility issues remain issues for the jury. They're not issues for the judge, and the judge is not trading in a robe for a lab coat to make a scientific judgment here. It is basically just that this meets a threshold that is sufficient to say that it is reliable enough for the jury to weigh it and determine the credibility of the experts. I had a case that was in the Ninth Circuit a few years ago in which the judge allowed the evidence in. The jury believed the expert, ruled for the plaintiff. This was a case dealing with a faulty engine that Chrysler had put out. The engineer had explained why the design essentially had been abandoned by every manufacturer because it caused a loss of power. But the judge just found this to be a little too incredible that a company that long in business could have designed something like that and not known this. And so therefore, he overruled the jury. But the Ninth Circuit said that that wasn't his job. And so therefore, the fact is that this was a credible testimony. It was shown by valid methodology. It clearly applied to this type of engine. And as a result, it was admissible. And once it was admissible, then the weighing of the evidence, the credibility of the expert was the jury's determination. So that's why, while this is a change and a change in emphasis, and we have also seen since then some courts being confused about really when to talk about the preponderance of the evidence rule and when to apply it and how to do it. We've seen a variety of decisions in the short time the rule's been in effect, and I think that's going to have to sort out over time. As Jeff said, many states adopted similar rules to 702. As I said, the advisory committee that drafted this does not think this is a change in substance, only in emphasis. So the question then becomes, have you been making the mistake they identified, or have you not? If you haven't, then nothing changes.
Thanks, Bob. And sorry, Justice McKenna.
Please go ahead. Before, I think you're going to speak about personal jurisdiction, but before you do, I realize this is a civil justice update, but I can't help but think how for so many years, forensic evidence that was considered generally accepted but had never been tested the way it was supposed to be tested. And so I think this applies equally to the government in presenting scientific evidence that has now been candidly debunked through the National Science Institute, et cetera. But I think we'll go ahead and turn to personal jurisdiction issues.
Yeah, just two more points on that. Actually, Justice McKenna, the point you raised is forensic evidence is called out as one of the items that the advisory committee was focused on. And one of the things in particular it was concerned about was claims that I can have this opinion to an X degree of reasonable certainty, which is something that, that's a phrase that many state laws sort of require as a substantive matter in terms of the sufficiency of the evidence, but it's phraseology that has caused problems in the realm of forensic evidence in particular because much of the methodology in many areas of forensic review are more subjective and less certain than advertised. And so that is something that the advisory committee has specifically asked courts to be on the lookout for and to guard against. And just to follow up on one thing that Bob said, Bob, I think I agree with almost everything you said, which I'm surprised to find myself saying. However, I will say that...
We're subtitling this the vice presidential debate.
Touche. The not enough literature sounding like a Fry rule, I think that there's overlap there. I think Daubert, it's correct to say that Daubert is a more sort of liberal approach to evidence than Fry is, but how much more liberal, I think, is the debate that we would have, right? And that we could fill a whole day probably with that debate. But in those cases that I referred to a minute ago, where there is a paucity of scientific literature, then you do get questions of, well, then how is your method reliable if you're reaching conclusions that the rest of the literature hasn't reached? And so that's how those cases do frame it in terms of reliability discussion, but I hear what you're saying, that it sounds a little bit like Fry. I think there's just more overlap there than perhaps you were allowing for in your comment. Let's move on to personal jurisdiction, and Bob can get me back when I give it back to him, personal jurisdiction. So the Supreme Court has done a lot of work in the personal jurisdiction space in the last decade or so, starting with the Daimler case in 2014, which was about general jurisdiction. This case didn't really change the game much for product liability defendants in my practice, but it sort of portended changes to come that would. In that case, just for reminder, it clarified, the Supreme Court clarified that generally speaking, general jurisdiction will apply, or it will hold a defendant to answer to a case either at their principal place of business or where they're incorporated. But a few years later, the Supreme Court decided the Bristol-Myers Squibb case, which was transformational for product liability defendants, at least in some jurisdictions. And in that case, there was a couple hundred product liability cases pending in California concerning the drug Plavix, and the question was the fact that there were a couple California residents involved in those cases enough to justify the exercise of personal jurisdiction over Bristol-Myers Squibb with respect to 590 other cases in which there was no connection to California whatsoever, beyond the fact that the company sold the drug there. And the court said that was not enough. It seemed to hold that a personal injury plaintiff in a product case can only assert a specific jurisdiction over a defendant in a state where the injury occurred, so where they took Plavix and where they sustained the injury that they allege was caused by Plavix, even if the defendant sold the product nationwide. So those seemed like two fairly straightforward rules, but it's gotten a little more nuanced since then. And in two more recent Supreme Court decisions that suggest that it will only become more nuanced and confusing as we go forward. So just to kind of cover those and then kind of project where we may be going forward after that, I'll talk about the Ford and Mallory cases. So the Ford case was kind of the follow-on to Bristol-Myers Squibb. This was a specific jurisdiction case decided a few years ago, kind of like BMS in the fact pattern. So the plaintiff, there were actually two plaintiffs, but I'll simplify it and just say it was one plaintiff. There's a plaintiff who bought a product that was sold nationwide, a car manufactured by Ford, in a state outside the one he was living in. So living in Montana, bought the car in Washington, has a car accident in Montana, and then sues Ford in Montana. And the question was whether, having bought the car in Washington, were Ford's contacts with Montana sufficient to justify the plaintiff bringing the suit in Montana? And the court held that yes, that was sufficient, because even though in BMS there was kind of a suggestion that you had to sue in the state that you were injured in or took the drug in, that's not really what, that was really looking at only one half of the equation that the court looks at when talking about specific jurisdiction, which is, does the lawsuit arise out of or relate to the defendant's contacts with the forum? And so in BMS, we were looking at the arise out of language, like if you were taking the drug in California or you were injured in California and you sue in California, then the contacts with California the suit arises out of the contacts in the state of California. In Montana, not so much. It doesn't arise out of Ford's contacts in Montana because they didn't buy the car there. The car wasn't manufactured there. It wasn't designed there. But Ford sells cars in Montana. It supports owners who have purchased Fords in other states who now reside in Montana through dealership maintenance, replacement parts, things of that nature. And so it relates to Ford's contacts with Montana. And so that was kind of the court's rationale in the Ford case for not necessarily expanding specific jurisdiction from Bristol-Myers Squibb, but clarifying what it meant when it was talking about what specific jurisdiction means, and so certainly rejecting a narrower reading of Bristol-Myers Squibb that was taken by Ford in that case. So since then, there have been kind of different takes on applying this doctrine in different cases. So there was one court in the California Court of Appeals called Daimler Trucks North America versus Superior Court. And there, the court found personal jurisdiction was established over an Oregon-based truck manufacturer where a California resident was involved in an accident in Oklahoma after the resident drove it there. So the truck was not sold in California. The accident didn't occur there. It was just the fact that the resident was from California combined with the defendant's in-state activities that justified jurisdiction. So that goes another step beyond the Ford versus Montana case, because there, not even the accident happened in the state where the case was being brought. Car wasn't purchased there, et cetera. So perhaps going, like I said, a step beyond where the Supreme Court was in that case. Contrast that with Yamashita versus LG Chemicals Limited, a Ninth Circuit case decided in 2023, held there was no personal jurisdiction where a Hawaii resident alleged injury from a lithium battery that was used in some other company's product that was purchased in Hawaii. But the defendants were a South Korea corporation and a Delaware corporation with principal places of business outside Hawaii that did not sell the battery directly in Hawaii. So the contacts that were raised by the plaintiff in that case were the fact that the defendants had shipped products through a Honolulu port, although not necessarily the battery at issue. They sold different products in Hawaii. Other consumer products sold in Hawaii contained the batteries at issue. And a third-party website sold batteries online. And these contacts, the Ninth Circuit held, were not sufficient because the claims didn't, even though there were some contacts, yes, the claims at issue did not arise out of or relate to those claims. So we have some, again, still some sorting out of what the rules mean now in the lower courts after the Supreme Court's decision. So there may be a return to the Supreme Court. One issue that the Supreme Court did not address in either BMS or the Ford case was the stream of commerce theory of personal jurisdiction, which also seems to kind of run through some of these cases, which basically states in its most expansive form that as long as you put a product into the stream of commerce and can reasonably expect that it will end up somewhere, that you could be held to answer to a plaintiff in court in that jurisdiction. The Supreme Court has tried to answer that issue in a couple of cases. It's never gotten a majority, and so jurisdictions continue to sort of split on that issue too. All right, so the other case that I wanted to talk about was the Mallory case, which we talked about the last time we were here, Bob. At that point, it was sitting in the Supreme Court, not yet decided. This is a case, a general jurisdiction case, where the defendant was not based in or incorporated in Pennsylvania, but ultimately it was determined it could be held to answer to general jurisdiction in Pennsylvania because the business registration statute in Pennsylvania requires businesses registering to do business in Pennsylvania to consent to general jurisdiction there. So there was a question, does this violate due process? It seems to be totally in tension with the Supreme Court's rule in Daimler. And actually, the Pennsylvania Supreme Court itself held that its own statute was unconstitutional. But the U.S. Supreme Court said, no, actually, you can do that. We have a case from 1917, the Pennsylvania Fire Insurance Company of Philadelphia versus Gold Issue Mining and Milling, which held exactly this, that you can consent to jurisdiction, so there's no reason you can't do this, at least as a matter of due process, in a business registration statute. But there's all sorts of extra opinions in this case, asking questions about, like, this is crazy, like, we just cleared all this up. Now states can just, like, pass these general, jurisdiction consent statutes, and, like, our work for the last 10 years is undone. Maybe this could be brought as a Commerce Clause challenge. Who knows? So a lot remains to be decided after Mallory, but the truth is, despite all of this wondering a lot of what's going to happen, not much has happened in the wake of Mallory. The Pennsylvania statute applies the way that it said it did. There's maybe one or two other states that have similar statutes. But every other state has rejected this theory of general jurisdiction on the ground that unless the statute, the business registration statute, very clearly says that you're consenting to general jurisdiction, then you're not consenting to general jurisdiction, and you can't sort of put a gloss on the statute that says otherwise. So it remains to be seen whether more states adopt statutes like this. There were some justices in Mallory who doubted that states would do this because it would potentially deter businesses from doing business there. But all these decisions and sort of the inconsistencies or revisions or nuances that come with them kind of raise new questions about what's going to happen next. And one area in particular of potential interest is what about internet contacts? And this is coming up in particular, and in many places, but also in particular in the social media litigation in which, full disclosure, I am involved. This was actually an issue that was expressly left open in a footnote in the Ford case. It almost goes out of its way to say, hey, we're not deciding internet cases. That's going to be crazy. So we're not doing that right now. And it is crazy, and now it's sort of come to light, at least to me, I'm sure it's been percolating for a long time, but it's become a focus in the social media cases. You know, some of the allegations in those cases, for example, are social media company X has a bad algorithm that's like, you know, targeting young people with ads that are bad for them. Well, where does that conduct occur? Does it occur where the person is using the social media application? Is the conduct actually the conduct of the social media company, or is it the conduct of the third-party advertiser? And so looking back at the kind of rationale and the logic of the Supreme Court's recent cases, they don't really provide clear answers to this, and this is what the footnote in Ford says. It's sort of, the questions that the internet raises are obvious. We could list them. They don't, unhelpfully. But anyway, that's a frontier where the questions have not yet been answered and could be the focus of a future Supreme Court case, since there's been very little guidance from it other than to tell us that none of its precedents apply in that context.
So when we discussed personal jurisdiction last year, I made the comment that the U.S. Supreme Court's contribution in this area amounted to less than zero because it was so confusing. They have added to that confusion since then. So let me see if I can help you sort out where those points of concern may be. The court continues to say that international shoe is the guiding light of personal jurisdiction, and then seems not to apply it. In 1958, in a case called Hansen versus Dekla, the court said, you know, modern technology is making it easier for parties to get together, to transportation, communication, all those things are probably going to expand our concepts of personal jurisdiction. And it seemed like that was the direction the court was going. And then, as Jeff said, with the Daimler decision in 2014, they sort of put a halt to that. It was an odd case. It involved foreign plaintiffs suing over Daimler Chrysler's involvement in Argentina in the Dirty War, using as an excuse to bring it in a U.S. court the fact that a subsidy, Daimler USA, operated in the United States. The court wasn't having it and emphasized that general jurisdiction, which has often been used somewhat generally by plaintiffs, really wasn't the proper way to go about these kinds of cases. It's more going to be about specific jurisdiction, but this one wasn't even close. It continued in that direction, culminating in the Bristol-Myers case that Jeff mentioned. There, the court said that the fact that there was plaintiffs from a variety of other states, including California, didn't mean that California courts could hear the cases of those plaintiffs who had no connection to the state, who did not purchase or order the prescription drug that was at issue in the state. And while it was distributed by a company located in California that continued to allow you to have jurisdiction over the out-of-state plaintiffs, for that defendant, you could not have it with respect to Bristol-Myers. They had to sue in their own states or in the places where Bristol-Myers was incorporated, such as Delaware, or where its headquarters was. And so there was a constant narrowing, it seemed, of the concept of personal jurisdiction, and it applied it as a matter of due process to state courts. And the fact of the matter is that most states have long-arm jurisdiction statutes that basically say our jurisdiction extends as far as the 14th Amendment will allow us. So all of these decisions then depend on the Supreme Court's attitude. Now, Jeff mentioned Ford. Ford was a case in which the court basically cut back on this. It opened the door to more. I particularly like Ford simply because I filed an amicus brief in the Ford case. I mentioned a fact that was not in the record, that was not part of any other brief, that Ford operated a website that was entitled Keep Your Ford a Ford, and it urged those who owned Fords to use original equipment parts, whether they brought it to a dealership for repair, whether they went to an independent repair shop, or whether they did it to themselves. Justice Kagan, for the unanimous decision in the case, used that information in the second paragraph of a Ford decision, which is part of the reason why I like the decision so much. Oddly enough, Justice Alito concurred, objecting to something that was not in the record. I don't understand that. Anyway, the fact is that what this did, and the connection to Montana in this instance, to use the example that Jeff did, was even more attenuated than Jeff described. This was a car originally purchased in Washington State, resold as a used car, not through a dealership, but to the person who was in the vehicle when it failed and was injured. And so as a result, there was this attenuated connection necessarily to Ford. Ford argued that there ought to be a causal link to this. So it must be either our manufacturer, general jurisdiction, suing us where we're headquartered or where we're incorporated, or you could sue us where it was originally sold, but those were the only places. The court rejected that. They basically said this was a national network, that they were servicing these cars all over the place. They had issued 2 recalls for this particular vehicle and allowed you to bring it to your local dealership. But they also recognized that there was an importance here, given this kind of national sales, to the states at issue, Montana being one, basically saying that we have an interest in the safety on our roads. And because of that interest, we have jurisdiction to make sure that the vehicles that are operating on our roads are safe. Now, since then, there was a Massachusetts Supreme Judicial Court case involving Chrysler called Doucette. And in that case, originally, just to show you how much Ford changed things, originally this was a car purchased in Massachusetts by someone who lived in New Hampshire, was failed and caused injuries in New Hampshire. They originally sued in New Hampshire because that's where everything happened. But before Ford, the courts said, no, you have to sue where it was sold or where there's general jurisdiction over Ford. The result was that they got thrown out of court in New Hampshire. So they brought the new case in Massachusetts. And this time, Ford was decided. And this time, Chrysler defended by saying, no, no, no. Under Ford, you had to sue us in New Hampshire. They're the ones with the interest on the road. And what the Massachusetts Supreme Judicial Court said was, no, no. You basically waived that issue when you argued against it in New Hampshire. And so as a result, there's this clear interest in Massachusetts where this car was sold, and that is another place where personal jurisdiction lies. Now, in these court decisions, the Supreme Court often talks about there's only 2 types of jurisdiction. There's general jurisdiction and specific jurisdiction. But the fact is, the court has also recognized a variety of others. Tag jurisdiction, for example, remains valid. And in a case called Burnham, written by Justice Scalia, tag jurisdiction is found to be a constitutional and appropriate way of doing it. Tag jurisdiction essentially being that you have found the defendant in that jurisdiction, you serve them with process because service of process is the basis for jurisdiction. Another is consent, and Mallory is an example of consent jurisdiction. There, clearly stated, Pennsylvania law said that by registering in this state, you are consenting to general jurisdiction, and the court found that that was still valid, upholding a century-old precedent. At the same time, there was a Georgia case also pending before the court because Georgia has a similar provision. Frankly, the Georgia case seemed like the stronger case, and so obviously, as a result of Mallory, the Georgia decision was valid as well. Now, Jeff is right. The court has strenuously avoided trying to determine when through the internet, you can get jurisdiction. But there's some interesting developments in the past year. And it's not just in the social media area, it's in the products area. There are two decisions of the Ninth Circuit that are worth looking at. The Ninth Circuit takes an attitude that the website is either passive or active. If it's a passive website, it's just like an advertisement where essentially it is the plaintiff that causes the product to come into the state, and there's no basis for asserting jurisdiction because personal jurisdiction requires a defendant to actively put themselves into that jurisdiction. But they found that to be the case in a case earlier this year, decided in July. In that case, Herbal Brands is a storefront seller of products in Arizona. What they discovered was that their products were being bought at tremendous discount by these New York residents who then established a store on Amazon in which they sold the products at a profit, selling it in Arizona among other places. And the question then was, could they sue essentially under the Lanham Act and under Arizona state law to essentially stop this process and get damages? And the Ninth Circuit found this was true because they found that the Amazon website operated by these New Yorkers was an active website. It basically caused them to ship products into that state, and that was the activity, the something plus that was necessary for the assertion of personal jurisdiction. I think these kinds of cases are going to become more prevalent, and they're especially going to become more prevalent as more and more products become smart devices. Why do I say that? I say that because the fact is that a lot of smart devices are licensed to you and not necessarily owned by you. They continue to be owned by the company. Two quick examples. Microsoft had an ebook business for a while. They abandoned it in 2019, finding that it was not sufficiently profitable. And what did they do when they decided to kill their business off? They deleted the books purchased by people off the devices that they had. And people protested. They said, I bought this book. Well, you bought a license for the book, not the book itself. And so that's why Microsoft could do that. In such an instance, Microsoft basically, by operating through the internet, had put itself into your device at your location and supposedly owned the software that was on your device. So that seems to expose them to personal jurisdiction. Similarly, Tesla, during Hurricane Katrina, what Tesla announced is that there was actually an ability, as people were trying to get out of the path of the hurricane, for Teslas to have additional ability to go further. That all they had to do was flip a switch at headquarters, and these cars' mileage was increased. And the reason they apparently do this is because they are encouraging you to buy a higher engine that has the same mileage, and so therefore they don't keep it. But in a public spirit, what they did was they enabled these cars to go further and not have to be recharged as quickly in order to escape the tragedy of the hurricane. Now, when that happens, you have obviously the company reaching out to that place regardless of where it is, and possibly also exposing themselves to personal jurisdiction as well as to potential liability in the future when they don't do that in a desperate situation when you call them or something like that. It shows that it has a capability that is there, that there's not necessarily any rule, and the question then becomes one of duty. So those are the kinds of issues I see coming down the pike that we really haven't faced in court to date, but they are emerging.
And I'll just say, sorry, to add one more piece to that. There are a number of concurring, like very interesting concurring and dissenting opinions in the recent personal jurisdiction cases where I think Ford had a couple of them. They were all concurring, but they were kind of like, maybe we should just start over with this whole personal jurisdiction thing. Like, this is all from the 50s. Like, it's a totally different world now was one of them. And then the other one was like, let's just go back to the 1860s.
Yeah, and
let's just
Justice
back
Gorsuch
when we-
actually questioned whether we should continue to abide by international suit.
So interesting to see how that all plays out, the 1860s view of how the internet contact should work when we get to that point.
Very interesting. Our court last year, in an opinion written by my colleague, Justice Todd Edens, who's here, and we actually teach state constitutional law together. But it's a case called Womble versus Kim. We recognized conspiracy jurisdiction, which I believe is a type of specific jurisdiction, but we held that basically under federal due process standards, there wasn't sufficient context to bring in the three law firms, Shook Hardy, Covington Burling, and Womble, into Hawaii for allegedly conspiring to sell tobacco litigation. It was basically tobacco litigation. So we said that there wasn't sufficient contact. But I can't help but think, I wonder whether in terms of consent jurisdiction, all these long-arm statutes, ours also says our long-arm goes as far as the federal due process allows. But I wonder whether there may be a time where people start challenging this based on state due process grounds. But anyway, I haven't seen that happen yet. In any event, I think we do have one more topic that I want to make sure that we get to, which is the SEC versus Jarchese case and the whole right to jury trial.
And let me start with that one. So Jarchese was a challenge to administrative law judges ruling and issuing civil fines, civil penalties to companies. And what this did was it challenged the appointment of the administrative law judges altogether. It challenged the fact that they would have this kind of authority, but it also challenged whether or not this was something that was subject to trial by jury under the Seventh Amendment and therefore ought to be before a jury rather than some sort of administrative process. When it emerged from the Fifth Circuit, it looked basically like it was a challenge to the New Deal. By the time it emerged from the Supreme Court, they decided not to answer the two other questions, but simply focus on the jury trial right. And by doing that, they said that this was the kind of thing that was within the responsibility of juries. Civil penalties are sufficiently like damages. Damages are a responsibility of the jury. And so therefore, this is something that Congress could not reassign to an administrative law judge to determine, but instead had to be a trial before a jury, and maybe there is a way of doing that through the administrative agencies or not. We're not saying so here, but we're saying that this is definitely something that can no longer be before the agency like that. This is quite revolutionary, and as a result, it has spawned quite a few challenges to different kinds of agency decisions, whether or not it needs to be before juries, and also taking up the questions that Jarchese did not decide. We're likely to see similar cases in the state courts as well, in which, again, the rise of the administrative state has been something that there are quite a few opponents to and challenges for.
Yeah, I'll just say, so the Seventh Amendment technically is not incorporated against the states, but the many states have equivalent constitutional protections. So it certainly seems like if you're just looking at what the Supreme Court decided in Jarchese alone, that could have implications for state practice, for sure. Whether it actually has a huge implication for SEC practice particularly, probably not, just because the SEC had already sort of in the light of these types of challenges stopped doing these juryless penalty proceedings within the agency itself. But I think Bob's pointing out is correct, which is that there's like an entire world of agency adjudications outside the SEC. I think the dissent in that case listed about 12 different agencies that had civil penalties, many of which had no authority to seek them in court at all. It was only within the administrative proceedings. And so if you just apply this ruling directly to those cases, like, they can no longer seek civil penalties until they change that aspect of their structure. So it'll be interesting to see how this goes. I mean, obviously, this is like one part of a much broader attack on the administrative state, of which, other components were present and vindicated in the Fifth Circuit ruling and not overturned by the Supreme Court, even though it only addressed the one and said it wasn't touching the other two. It didn't vacate those rulings. So that's going to continue to be an issue in the Fifth Circuit, and specifically, right, like the issues are, the commissioners can only be removed for cause, and that was like limiting the authority of the executive to appoint officers. And the other issue was delegation, whether it was appropriate for Congress to just sort of shrug and say the SEC can figure out whether these things should be in court or not. Those potentially have broader implications too, those two issues, even if they're confined to the relatively kind of narrow facts that they were addressing. If this like non-delegation concept gets pushed further, you could see it eroding like a huge portion of the administrative state. So this is definitely like live out there, and there's a lot of litigation around it. So I imagine that a future panel will be talking about the next case. In fact, on the same day maybe, or at least the same week, there were two other admin law cases decided by the Supreme Court, one of which got rid of Chevron, which is kind of a big deal, right? And the other one, I can't remember what it did. But in any event, there's a lot of activity in this area, and this, the practical implications of JARC for SEC practice may not be super broad, but what it suggests may be coming, and its potential implications for other administrative practice could be quite broad.
And I'd like to emphasize one thing that Jeff did mention, and that is the right to trial by jury in state constitutions. I, too, have taught state constitutional law, and the most frequent formulation of the right to trial by jury is that it shall be inviolate in state constitutions. That's as strong a protection as you can imagine. Only two states really do not have a state constitutional right to trial by jury. Louisiana, because of its civil law tradition, and Colorado guarantees it in criminal cases only. The way the court went about looking at the Seventh Amendment is using a historic test, which is the test that almost every state uses as well. Is it a right that was essentially a prerogative of the jury at the time the constitutional provision was promulgated? And so it's interesting, and it's worth looking at from the perspective of a state court judge to see how the court went about it and how that applies, or how it has been applied in your own state. The interesting thing about this is that there is a 1978 decision from the Supreme Court, a case called Feltner, in which the court also dealt with that. It was a unanimous decision written, 1998, I'm sorry, written by Justice Thomas, in which the winning advocate was a fellow named John Roberts, and in which they looked at a question of civil penalties, which Congress had assigned at that time to an agency, versus damages. And with respect to damages, they applied the Seventh Amendment and said that that really had to apply here, a case called Feltner. So that's something that I think also, besides the administrative law aspects of this, is something important to know.
Very, very interesting. Our state constitution, like many, says that we have a constitutional right in civil cases for suits under common law, but we've really adopted the legal versus equitable distinction to determine whether or not there is a right to jury trial. But I think this is going to be a very interesting issue. I will say that our court recently reiterated that we are not abolishing Chevron deference. And so, I think it's really important for all the state court judges as to how we're going to interpret our state constitutions and our state laws. But I think we have a few minutes. I'm wondering if we have questions now. Yes, please.
Please use the microphone.
Yes, please use the microphones.
Good morning. Thanks for
Morning.
your time today. One of the questions or one of the issues that I struggle with in my courtroom, dealing with 702, back to the first part of the presentation, isn't so much the scientific evidence, it's and I had to write some notes down, I just had a case about this, I just ruled on it, probably incorrectly from what you're going to tell me, but we'll see. And that is what you're seeing regarding the parameters or the scope or the left and right limits of expert opinion that's not based upon scientific principles, but based upon experience, and experience alone. I recently had a case, I won't bore people with war stories, but this gives you the background of my question. I had a case, it was a wrongful death, officer-involved shooting. The family of the decedent, who was shot by the police officers, brought in an instructor from the local police academy, whose entire opinion was based upon experience, what I've seen in my career, what I've taught. He didn't help his case by not citing a whole lot of literature when he said it. It was almost entirely his opinion. I ultimately let it in and said this goes to the weight, but certainly the defense had a strong argument under 403 to say, you know what, you've got an expert witness coming in here saying that this is what the officer should have done. Of course, the jury is just going to agree with whatever he says. But back to my original point, it's more difficult when you're dealing with experience evidence or experience opinion because there's no formula you can put it into. And I'm just wondering what you're seeing regarding the parameters of how that's coming in. Thank you.
So I'll go first if that's all right. I mean, the advisory committee notes actually speak directly to that issue, and they say that experience can be a basis for reliable testimony. So that's not like a huge amount of guidance, because, right, like that answers the first question, but then how do you do that is your question. And for that, it really is going to be kind of case specific. I think the expert has to be able to explain, and, you know, coming from this isn't really a plaintiff versus defense thing, because both sides use experts who rely on experience. But I would say the way this is played out in cases where I've been involved when that's been an issue is there is a little bit maybe higher scrutiny of the expert just because of the lack of objective sources like the kind you're describing. But as long as the expert can kind of define in clear terms like what the experience is, how it relates to the opinion that they're forming, and kind of walk through those steps and they're reasonably logical, then the rest of it is probably for the jury.
And I agree with that. The experienced expert is admissible. Again, the real test, is it a reliable experience for purposes of this issue? And what you described certainly sounded that way.
I wanted to ask a question about 403 and the 702 analysis. And I know you mentioned earlier that the weight and credibility issues go to the jury, but in terms of the court's gatekeeping role on 403.
Could you speak a little closer to the mic?
In terms of the court's gatekeeping role, vis-a-vis 403, as you're doing the 702 analysis, what's your perspective about that? Meaning, do you think, I mean, the court is always doing a 403 or can do a 403 analysis as it's deciding the 702 issues, even if 702 is the same as amended as it was before or not. So what's your view about the impact of the court doing that? Because to some extent, even though the 403 analysis deals with the issue of prejudice, I do think the court is implicitly making some determinations that bear, to some extent, tangentially on some of the proffers that are being made. At least that's how I see it. I'm just curious. Let me hear from you.
It really sort of depends. I mean, it's kind of an abstract question the way you framed it, but I do think that 403 is certainly a proper thing to consider. Just because something is admissible under Rule 702 wouldn't necessarily mean that it bypasses Rule 403. It would really just depend on what the issues are. You know, does the potential for prejudice, like clearly whatever the language of 403 is, clearly outweigh the probative value, and that may take on sort of unique considerations in the expert evidence, because there are often situations where a plaintiff can't proceed without expert evidence. There's certain cases where causation, for example, in a product liability case, almost always requires expert testimony as a matter of substantive state law. So if you don't have an expert at all, it's summary judgment time. And so, you know, you may need to take that into account when doing the Rule 403 analysis. But there certainly can be expert opinions, and a lot of times where this has come up, where I've seen it come up in the Daubert sort of in limine stage is an expert has 5 or 6 opinions, right? 2 or 3 of them are kind of core expert opinions that probably aren't Daubertable, even though we may take a shot at it. But then there's 3 or 4 accessory opinions that are like, this company's bad. Like, they do bad things, and I don't like them, right? Like, that's a Rule 403 issue. Even though it's dressed up as an expert opinion, that's one where it would make sense to sort of take a hard look under Rule 403.
And that's just it. It's easy to bifurcate the different parts of an expert's testimony and say this part is admissible, but this part isn't.
Good morning. If you could give us the site of that last Supreme Court case where they ruled that civil penalties have to go before a jury. It's SEC. Do you have a site to that? And then I have a question.
SEC versus Jarkesy, Jarkesy. I don't have the citation
Okay.
with me.
I'll
So-
look it up while Bob answers your question.
Okay, in that case, did the court address whether the SEC even has the authority to determine that the defendants were liable under the statute? I mean, because if you're going back to history, why would the court distinguish between civil penalties versus the initial authority of the SEC to even determine liability, A? And B, in New York, for example, we have this proceeding called Article 78. So whatever an agency does in terms of civil penalties can be reviewed by the judge, albeit without a jury. So if a judge does have the authority to review, would that eviscerate the problems that the court saw in terms of lack of jury trial for civil penalties?
So while the court is capable of going beyond the question presented did not go beyond this.
Okay.
And so that's probably the explanation for why the court didn't discuss anything further.
Okay, and in terms of curing it by, having state court review of the penalties, that's not sufficient because there's no jury trial initially on civil penalties? Because that's what we have in New York, for example.
Right. And there's a case called Gasparini in which the court looked at New York's requirement that there be certain comparisons between jury verdicts in order to determine whether or not it was valid, and found that to be within the Seventh Amendment's protection. So there's some ability to do something different in the states, particularly as Jeff pointed out, the Seventh Amendment has not been incorporated and applied to the states.
So
Okay.
it's docket number 22-859. I've not been able to find in this short time the Supreme Court opinion, but that's the, if you Google that, you can find the opinion online. Yeah.
I have another question about Jarkesy. So it's an interesting question. We have it a lot in Florida, the interplay between the administrative law judges and what they're doing, and maybe they're intruding on that jury trial right. If you think of the Gallardo decision on Medicaid, all right, so in Gallardo you have if a plaintiff receives a tort recovery but a state has paid through its Medicaid program payments. Under many states, including Florida, the Medicaid program has a right to recover a percentage of that tort recovery. And that in Florida is going before administrative law judges. And they're doing all kinds of things, like looking at the projected future payments from on the tort settlement and doing a lot of things that you would traditionally see in a tort suit. What kind of impact do you think Jarkesy is going to have on that type of administrative law practice?
So I think there'll be a big fight about whether that's an equitable or legal remedy at the first instance, assuming that the state observes that distinction in its jury right practice. One of the things that was sort of left open after Jarkesy is, perhaps the SEC can still do administrative proceedings to get purely restitution or disgorgement type recoveries, because those are more equitable remedies and they're not, the legal rights that entitle somebody to a jury defense. So that would be my first reaction. I don't know, Bob, if you have a different.
Yeah, my short answer to your question is that it's put it all into dispute.
Absolutely. Thank you.
Any more questions?
Well, I have one question. Bob, can you remind us the name of your book, please, when it goes on sale, and where we can buy a copy?
So it is available to order pre-publication on Amazon, and the book is called Supreme Anecdotes, Tales from the Supreme Court.
And I think the next question is, if we come back next year and you're here, will you sign it for us? So thank you so much. One thing about these sessions is that we are very good about starting on time and ending on time. I think we have about 1 more minute, but I think we're fine. We'll go ahead and enter our recess. Thank you so much to our wonderful panelists.